Wonderful. Then I think it's as good a time as ever to begin. So good afternoon and welcome everyone. My name is Kyle Sutton and I'm the editor-in-chief of Volume 56 of the New England Law Review. The Law Review in combination with the Sandra Day O'Connor Honors Program are incredibly excited to welcome Professor Mark Osler. For any of you that were able to attend the Law Review's Fall Symposium, you may recognize Professor Osler. Today we're here though to discuss his article, The First Step Act and the Brutal Timidity of Criminal Law Reform, as well as the response pieces to it. This article is featured in volume 54 of our journal. While this event was originally supposed to happen in early 2020, the issues that are discussed in this are just as timely as ever, and we're so incredibly grateful to have Professor Osler here to share his time and expertise. I'm going to let Professor Osler introduce himself and his piece, and then we'll hand the mic over to Matt Bramall, who is in the honors program, to moderate the questions that have been submitted from the Law Review and the honors program. So Professor Osler.
Okay, thank you so much, Kyle, and thank you for putting all of this on to the editors and others. I think the issue came out really well, and it's such a remarkable thing to have people respond to what you write in such a direct way and add to it, which is part of what I got to see happen here. I'd also like to thank Professor Cecilia Klingel of the University of Wisconsin Law School. I'm actually down in Madison. I'm not in Minneapolis right now. And I'm using her office, which is much, much cleaner than mine, which is a great thing. You know, Kyle, you mentioned that the article, the issue really was delayed, like everything else, because of COVID. And I wrote this piece a few years ago, but it's a better time to talk about it now than it would have been then, because things have happened since then, things that really are discussed in the article itself. That passage of time, I would really have loved it if the passage of time had dispelled what I warn about in the article. But in fact, the opposite has happened, that instead we're looking at really things slowing down as much as anything else. Now, just to introduce myself a little bit, I'm a former federal prosecutor. I was an assistant U.S. attorney in Detroit from 1995 to 2000. One of my fellow AUSAs there at the time was Barb McQuaid, who's one of the responders, and wrote a really nice piece in response, and I'll get to that later. After that, I taught at Baylor for 10 years down in Texas, Waco, Texas. People always ask, did you know the Gaineses? And actually we did. The Chip and Joanna lived 2 doors down from us. Then got tenure there, and in 2010 moved up and started teaching at the University of St. Thomas in Minnesota, which is where I am now. Now, in the article, part of the point that I'm making, and where I start out with it, is that the First Step Act, which was passed in 2018, December of 2018, that made some really significant reforms, was signed by Donald Trump, had strong bipartisan backing. That was one of the few moments during the Trump administration when you really did have a bipartisan initiative that meant quite so much. It was named the First Step Act because people wanted to signal clearly that it wasn't the end of the line, that there needed to be follow-up to it. There needed to be things that would explain, complete, and extend what was set out in the First Step Act. A few of the things that were in the First Step Act, and it had a lot of provisions, is it changed some statutes. For example, the way that people could be charged with possessing a firearm multiple times. One of the cases that spurred that was my client, Weldon Angelos, and he was selling marijuana, had a gun with him when he did so, although he didn't use it or show it or anything. And an undercover went and bought from him 3 times. Well, the way that the stacking provision worked, he got 5 years mandatory for the first time he possessed a gun, and then 25 for each of the second 2, even though it was just consecutive weeks. And that meant there's a mandatory 55-year sentence for selling a small amount of marijuana while possessing that firearm. And they fixed that in the First Step Act. They also made significant changes to the way crack is sentenced with the mandatory minimums and made it retroactive so that people would seek to have their sentences reduced by going back to the court that it came from. It also established ways for people to earn time off credits by taking programming in prison. These were all significant things. I mean, in the piece, I don't mean to denigrate the First Step Act at all. What is striking about it and what really is at the core of my thesis is that sadly, it's so unusual that we don't see reform happen very often. And when it does, it's almost like lightning striking. Even when everything flashes red, basically, we're terrible at turning the ratchet back. We're terrible at reducing sentences. We're pretty good at increasing them. But when it's time to turn it back, there's so many forces that push back against that. It's not just sentencing, it's other kinds of reforms as well. I live and work in Minneapolis, and there we've had really a terrible couple of years, and the tragedies on the streets of our city have impacted the entire world, have really been the focus of discussion and protest all over the world after the death of George Floyd. Now, unfortunately, just 3 blocks from my own law school, we had the death of Amir Locke just last week in a no-knock warrant situation. No-knock warrants were one of those things that people focused on reforming after George Floyd, largely because of not George Floyd necessarily, but the death of Breonna Taylor in Louisville. You'll remember she was asleep in bed and during execution of a no-knock warrant, which was shot dead. A complete innocent and a bystander basically to what was being done. But even when you have that kind of focus, you have people on the street all over the world, and you have a kind of reform that is so clear, it doesn't really happen very easily. I mean, in Minneapolis, the mayor said that he had banned no-knock warrants. The city council said that they'd restricted them. But the truth is that the Minneapolis Police Department was using them as much as ever. In just the 10 months after the supposed ban, they asked for 90 no-knock warrants. And then we come to the next tragedy. And that's why what I'm talking about in the article matters so much. It's because in criminal law, I always tell my students, criminal law is all about tragedy. It just is. It'll wear you down with tragedy the closer you look at it and the more you engage with it. That we can't unmurder a person. We can't unrape a woman. The best we can do is try to prevent that from happening the next time. And that cycle of tragedy, sometimes we pay attention, but we don't really change things. And, there's tragedy of over-incarceration too. And the cost of our failures, whether we're not policing well, we're policing too much, we're incarcerating the wrong people and not the right people, or we're incarcerating people for too long. Our failures are measured in human lives, in freedoms, and in social unrest, and that's what we've seen. I think, in retrospect, I refer to the problem as the slows, which is borrowed from my in-house historian, what Lincoln said about one of his generals, McClellan, that he wasn't moving fast enough and he had the slows. But really what we see in criminal law is something that is more complicated even than in general, not wanting to engage with a skilled enemy. I want to play some things out that are in the article. I'm not going to rehash the whole thing, certainly, but just to set the template for some of the discussion we'll probably have in a little bit. One of the things that I talk about in the piece is crack. That crack cocaine, it became super criminalized, basically, in the 1980s. In law, not all moments are equal. Some moments are tremendously significant, and they're not always the ones that we see coming. In the mid-1980s, we had this sea change in federal criminal law. There were several things that happened in the span of just a few years. we eliminated parole from the federal system, and there's still no parole in the federal system unless people were sentenced before these changes happened. We created mandatory sentencing guidelines that ended up jacking up sentences. Congress created mandatory minimums for many crimes. Regarding bail, they got rid of bail for trafficking cases, drug trafficking cases, and created presumptive detention, that there was a presumption that the person should be detained without bond if it was a drug trafficking case and a certain number of other cases. And it's also during this period that Congress put into the guidelines and into the statute a sentencing ratio that people were sentenced the same for 1 gram of crack as they were for 100 grams of powder cocaine. That sounds so scientific, doesn't it? And normative, that how much more serious is crack? Well, it's 100 times more serious, but it's just made up. And that's one of the real tragedies of it all. We're used to seeing numbers and just assuming that if there's a number attached to something that it makes sense. And that's not always true. I doubt Cecilia has any of these magazines here, but if you look at a fashion magazine, on the cover, it'll say 87 great looks for fall. Well, how many great looks for fall are there? There's 87. It's right there. And that's the way 100 to 1 worked. And it was deeply flawed, not thought out, and thoroughly bipartisan. This is something that Democrats and Republicans alike took up. In fact, part of the backstory is fascinating, that there was a basketball player named Len Bias who died, overdosed on cocaine after he was drafted number 2 overall in the NBA draft by the Boston Celtics. Played for the Maryland Terps. And of course, Maryland is kind of the hometown team for people in DC. And that matters because this is the guy that senators and congressmen were watching play. And then he gets drafted by the Celtics, who in the 80s were a powerhouse. They had Larry Bird and Kevin McHale. And now somehow they end up with the 2nd overall pick. And the guy dies when he goes to the draft, or when he's back in the dorm shortly after the draft. And so they lose the pick. And the Speaker of the House at that time in Boston was a guy named Tip O'Neill, well remembered there. And it was Tip O'Neill and Ted Kennedy came back to Boston. I'm talking to the right crowd for this. And, people were irate about crack because crack had robbed the Celtics of this great draft pick. And it was Tip O'Neill and Ted Kennedy that were some of the biggest proponents of the 100 to 1 disparity between powder and crack. It didn't make any sense. Was it racist? I don't think it was racist in the sense that when people passed it, they thought, oh, this is going to, finally incarcerate Black people. It was predictable that would happen. And probably some people did predict that. But I think, and a professor at Yale, James Foreman Jr., wrote a really good book about this called Locking Up Our Own, that it's complicated, that initial impulse. But once the numbers came in, once we started prosecuting these cases, and I prosecuted some of these, so I know, what we saw is that the people that were being prosecuted were Black, almost across the board. I think every single person I prosecuted out of dozens for crack was Black. And at that point, that's given that narcotics are sold and used at about the same rate by people of all races. You don't see big disparities in use and involvement in trafficking. But we just had this incredible focus on Black communities that was part of the Project on Crack. And the disparities are striking. In fact, there's an initiative right now in Congress that would go back and fix some of these old sentences. And 91% of the people who would benefit from that are Black. And so racist at the start? No, probably not. Not for most people. But once we knew how it was working, I think probably it was. The Sentencing Commission saw this because they're a data collecting organization. And they tried to get rid of it, the disparity. In 1995, they issued a report recommending that, and it didn't work. In 97, they did again. In 2002, they did. and in 2007. Now, finally, in 2010, you have to remember, this is something that by this point is 20 some years old. During the Obama administration, they changed that ratio to 18-1. There is a bill in Congress right now to make it 1-1, which is probably what it should be. Crack is made out of powder cocaine, after all, but it's floundering. It hasn't passed. It's been rolling around in Congress with bipartisan support for years now, and it still hasn't passed. And so when I talk about the slows, that's one really obvious example of it. And it's not the only one. I talk about marijuana, the scheduling of marijuana in Schedule 1, and the way that seems really intractable. So we've got this dynamic of the ratchet making sentences longer, going quickly, but very difficult to push it back the other way. What causes that? I talk about some of the causes in the piece. I'm sure there's others. It's not an exhaustive list. One clearly is politics and the appeal of tough on crime policies. That we're seeing that right now, as there's been an uptick in murder and some forms of violent crime in some cities, that people are saying, well, we must respond to that with tougher sentences. We must be tougher on crime. Now, there's a lot to be said about that approach. And one is that we know that if we want to deter crime, and often that's how this is promoted, is that if we have longer sentences, people will choose not to commit murder. That kind of assumes that these murders are rooted in rational cost-benefit analysis. That's just not true. People who are, at a gas station and robbing somebody and then shoot somebody, they're not thinking through the sentencing consequences and evaluating that compared to the, anything else. There is some statistical basis for believing that if we solve more crimes, that can deter crimes. But that's something different. You don't see politicians in a situation like this saying, well, let's solve more crimes. They're mostly saying, let's deter it by having longer sentences, partly because that's something they control more directly. Another cause is really the way the media treats crime. And this is something that, I borrow almost wholesale from Rachel Barkow in her wonderful book that was the subject of a symposium earlier. Basically, crime happening is more interesting than crime not happening. And the episodic nature of the news is that, that's what you're going to see. That if there is a carjacking on Arden Avenue, then you're going to pay attention to that. Now, if that one carjacking is the only one for the month, and the normal number of carjackings in that city as a whole is 6, boy, that's actually great news. But the one carjacking and the woman talking about the drama of it and the real tragedy that comes from something like that, not to diminish it, is what ends up on the news. And people think, oh, look at this carjacking. And so that's just the way the media is. But what they don't talk about is the successes. Crime going down generally, that just isn't very newsworthy. Even when there's some things that are really specific that we've done right. One thing that I think about often relating to this is that when I was a prosecutor, one of the problems we had in the United States, and it was a real one, was that people were cooking up their own meth. And, meth is a dangerous drug. I'm glad it's illegal. But one of the dangers with meth, unlike, say, heroin, is that you could make it in your garage, and people did. And that created all kinds of problems. Places blew up. Kids were exposed. There were toxic chemicals that were involved that spilled. And so you had all these collateral things that went with that really were bad. And so there were sentencing enhancements for people who were manufacturing meth that were put into place and things like that, but it didn't seem to have much of an effect. What finally worked was an administrative measure, because one of the ingredients of that kind of homemade meth was pseudoephedrine. And, it's cold medicine. And some of you may have noticed that if you want pseudoephedrine, type cold medicine, now you have to go up to the pharmacy counter and give them your driver's license and be put into a log. You don't need a prescription. They're going to keep track of you. And they limit the amounts that anybody can buy. And that really did a huge job of getting rid of the labs. That worked. But I'll bet you didn't know about that, because that's not a news story. Crime doesn't happen isn't what's in the news. Another thing that I talk about as a cause is race and racism. That, dog whistle politics are often about criminal law and race, going all the way back to Willie Horton. And again, boy, everything I talk about seems to be about Massachusetts. But when Michael Dukakis was running for president, and George H.W. Bush ran an ad against him about a guy who'd been let out on a furlough named Willie Horton. And they had this, super close-up of his face, and they used the image of a Black man to scare people about crime. Now, that wasn't the end of that kind of use in politics. It's right up to the current day. Donald Trump talking about crime in Chicago and specific crimes in Chicago and parts of Chicago even was that same kind of dog whistle appeal to race. And to be clear, it's not just Republicans who do this. Almost everything that I talk about, good or bad, it's been bipartisan. Another thing that I point to in the article as causing the slows is the power of prosecutors. Ronald Reagan was right in saying that bureaucracies protect their power ferociously. Rachel and I wrote another piece in the William and Mary Law Review about this, and about how prosecutors just don't want to be second guessed in a way and don't want to give up any power. In the clemency projects that I've worked on, we see this all the time, because in the federal system, the clemency petition goes to the local prosecutor, my old job, and they ask for the opinion of the local prosecutor. And almost always it's no, because really it's an admission of having been wrong about something when they say that. And there's one case that really brought this to the fore for me. We got a hold of a really good case, a guy who committed a long ago drug crime, nonviolent, who had been a model prisoner, had accomplished incredible things, had a great reentry plan. And that petition that we prepared goes to the U.S. attorney. We got a hold of what the U.S. attorney wrote to the pardon attorney in response and opposing this. And this is the way he wrote. The clemency application details what appears to be a remarkable turnaround during his time in custody. I cannot offer any insight into the representations about his progress, nor can I be of much assistance in evaluating whether the changes, if true, warrant clemency. Jailhouse conversions are not uncommon, and I have no tools or experience with which to evaluate which ones are genuine or may endure beyond the confines of imprisonment. Just dismisses the entire work that this person has done in rehabilitation. And I think that's unfortunately consistent with what other prosecutors have done too often. The other thing too is that in the federal system, more than in state systems, but there's some of this in state systems as well, the chief advisor on criminal law is prosecutors. When the president wants to make a change or is considering something, they bring in the DOJ. But there's no other body that plays a comparable role. There's nobody from the other side. And I throw out sometimes the model of what if that was flipped? What if someone ran for president and they said, if I'm elected, I'm only taking advice on criminal law from the federal defenders. I'm going to have, as the attorney general, a federal defender. I'm going to have, my close advisors on all these issues, the federal defenders, and I'm only going to listen to them about these things. Well, people would say that's crazy. There's two sides to this. That would be a totally biased viewpoint. But the mirror image of that is basically what the reality is in the federal system with the influence of the Department of Justice. Another thing I point to is the fragmentation of advocacy in this field. I go to conferences where there's a bunch of people who are advocates, And everybody's got their own organization. We'll go around the table, and instead of there being 6 people from the same organization, everybody's got their own that's doing its own independent thing. And that dilutes any one message. Finally, I talk about the lure of incrementalism, of baby steps, making small changes instead of big ones. I include in the piece a quote from Georgetown professor Sean Hopwood, somebody I really admire, and someone who did time in prison and basically wrote his way to success after he was out, and while he was in as well. And he defends incrementalism as it's we get something done at least, and that's true. I think that it's a cause of the slows, but out of them, it's probably the most sympathetic one. Now, how do you fix this? That's the question, isn't it? I suggest more unified advocacy, that we confront politics in the media, and that often when the media relies on anecdote, the answer is data. And data is always going to be more than one data point, whereas anecdote is almost always just one. As for racism, I think we need to name and shame racist appeals, call them out. And again, data is often the way to counter that. And diluting the prosecutor's influence on policy is important as well. It's shocking. I've done a lot in my career since 2000. I wrote a casebook, on comprehensive casebook on criminal law. I won an important case in the Supreme Court. I was Wacoan of the Year. But when I appear on TV, almost always at the bottom, it says former federal prosecutor, even though that was 22 years ago. That's the hook. That's what they care about. I want to talk briefly about some of the responses that were included in the issue from other scholars. And frankly, I think as a whole, they have as much to offer, more than my article does. Jalila Jefferson Bullock talks about centering the system on human dignity. And I was reading her piece and saying things out loud like, right on, and that is so true. My margin notes were exclamation marks and things like that. It wasn't something I addressed in my piece, and that's a failing. And I love what she did with it. I mean, the complexity of victims and offenders, of the traumatizers and those who have been traumatized, and the connections between them are deep and complicated. And centering the system on human dignity is, as a broad goal, something that really is well taken. My old colleague, Barbara McQuaid, talks about focusing on things other than sentencing. And I agree with everything she suggests, that our educational system needs to provide more even-handed chances for people, and the same kinds of resources and training to kids, regardless of where they live and what their parents might do. And when she talks about reentry, absolutely, reentry is really crucial, and we do need to focus on that. Now, all of that I don't think cuts against what I'm saying about sentencing, though. I've never done improv comedy, but I know people who have, and they've told me that the central tenet of improv is yes and, that you take what the person did before, you say yes, and you add to that. And I think all these things are yes and, that sentencing reform is yes and reentry and education, that to favor one isn't to disfavor others, and they're interconnected in sometimes often unseen ways into that web of a community. Adam Stevenson from the University of Wisconsin, I'm right down the hall from his office, I think. His piece steers towards clemency, which I tend to do a lot myself. But he also talks about how the bipartisan consensus that I talk about is shallow. And I think that's true sometimes. That is, we've seen some backing away by some people on the right as crime has gone up from reform, but not uniformly. I really see a deep and real commitment from two groups of conservatives, and frankly, the commitment from them is greater than from most progressive groups. And one is libertarians. I'm sympathetic to a lot of libertarian tendencies, but libertarians, one thing in common is to have consistent principles for the most part. And in this area, they're often aligned with what progressives believe. Now, to a much lesser degree, there are Christian conservatives that, as a faith imperative, do see the need for reform in these criminal justice issues. And then Joyce White Vance's piece, she says, don't reject the prosecutor's role in reform. And I think I loved her piece. I thought it was fantastic. What she said was very compelling and true. And she's correct in noting the incremental changes that were made in the Obama era, the same way that Sean Hopwood said that these are good things, and they are. She also points out that prosecutors are gatekeepers for key decisions. And that's true. But maybe too often they're the gatekeepers, and that's part of the problem. And certainly transparency in the decisions they make, for example, in charging, I think would go a long way towards correcting some of the problems that we talk about. My favorite part of her piece, and this is part of her genius, and you can tell she's a problem solver, is she sets out three key conditions for DOJ to have a role in reform. First, commitment from leadership. That is so true, and we haven't seen it very often. People sometimes point to Eric Holder, and she does, in fact, but there's a lot that Eric Holder left on the table. I saw an interview with him after he was Attorney General, and he was talking about he couldn't understand why marijuana was still in Schedule 1, the most serious narcotics. And I was yelling at the TV because, as Attorney General, he could have changed that. It's part of the CFR, and he didn't. The second thing that Professor Vance talks about is data-based education for line prosecutors. I'd never thought of that. Please, I think that's a fantastic idea. But her third point is maybe the most important one. And I feel like we're writing a response to her response, to amplify these points, which is she says we need to change the metrics of success for prosecutors away from how many people you lock up and for how long. I think that would be a huge and great change if we made it problem solving. Did what you do with criminal law, does it reduce crime? Does it solve a problem? Are fewer people being traumatized by what goes on? That would really matter. It was really an honor to get these extensions of what I said in the piece. And I greatly appreciate it, especially from these people that I admire so much. And you all did a great job of recruiting them. Now I know there's a bunch of questions, so I think it's probably time to turn to that.
Hi, Professor. So your first question is, in the article, you mentioned how media may negatively affect the public perceptions on crime due to over-reporting and choosing stories that will grasp their audience's attention. But do you think that certain social media platforms help bring more attention to injustices that occur? And do you think it could also be an effective way to bring attention to certain reforms and activist groups?
Yeah, I think that's a great question. And going to social media, especially that what I talk about in the article is mostly traditional media. And so this question is really turning towards social media and highlighting that social media has an ability to help reformers in terms of countering mainstream narratives that may be anecdotes based instead of being rooted in data. I think that's absolutely true. That, look, I mean, I wasn't on Twitter, and Rachel Barkow said, you have to get on Twitter. It's where people talk about important things. And she was completely right. Yesterday I tweeted about Amir Locke, and I had a thread explaining some of the aspects of what happened in that case. And it got all kinds of really interesting engagement. One of the beauties of social media is there's a certain rough equality that we all have there. If you make a good point, you make a good point. And I do think that, I mean, people like to knock down social media as being a basis for disinformation. That's true. It's a basis for disinformation that you don't find in the mainstream media. But it is also the basis for information that you don't find in the mainstream media. And I think that's going to be really important. And in the end, social media is a net good for reform and reformers.
Do you have any hope for an acceleration in criminal justice reform in the next decade?
I do. I'm an optimist, and I always have hope that things are going to get better. That we have this chance, this divided society in so many ways, but in this field, we have a certain bipartisan consensus, not by everybody on either side, but a significant one that you don't find in other areas. I mean, the First Step Act, the fact that it passed, that picture of all these people standing behind Donald Trump was pretty remarkable. And that's something that does give me hope, is that it is something that is truly bipartisan. Now, I do think, though, that to really make change at the federal level and at the national level, we're going to need to elect a president who cares deeply about these issues and who's motivated on it. Now, President Obama was. President Obama did things that no president had done before. He visited a prison. He took a bunch of people who got clemency out to lunch and talked to them about their stories. He, at the last couple of years of his administration, when he was done with work and he'd go back to the residence part of the White House, he carried bags full of clemency petitions to read in bed. I mean, I have this image in my mind of, him looking at something and then asking Michelle what she thought, and, them talking about it back and forth. But we need somebody who cares deeply, for whom this is an important issue and who's not timid about it. I don't think Joe Biden's that person. I don't think that Donald Trump was that person, but there are people on both sides for whom this issue really matters, that is embedded within their principles. And if there's going to be real change, I think we need an ascension of leaders for whom this is an important issue.
If there were one reform that you could make today that would be the most impactful, what would that be?
I only get to pick one, huh? I'm sure people would expect me to say clemency because I do so much work in that area, but I think that probably the one that would make the biggest change is actually the one that Joyce White Vance set out, changing the metrics of success. That if we somehow could, for prosecutors and law enforcement in this country, focus them on solving discrete problems, as opposed to measuring success in terms of how many arrests you make and how many people you incarcerate and for how long. That story I told about meth, that's something where an administrative measure solved a problem. And that's even better than locking a lot of people up to solve the problem, because nobody loses their freedom. And I'd love to say that the one reform that I think is most important is one of the ones I set out, but it's not. It's one that one of the respondents set out. But I think it's really well taken, because anytime we reevaluate what success is, we're redefining where our efforts are steered. And more than anything, that's what's needed. We're seeing that, with some of the progressive prosecutors, Larry Krasner in Philadelphia, Chesa Boudin in San Francisco. There's some movement towards this, and both of them have really led with data, with trying to get a sense of where the problems are are most compelling, and then going after that and trying to solve the problems. Now, their success in doing so, mixed as things usually are. But that's the one I would pick if I had to pick.
In your article, you argue achieving real long-term change will require not only changing sentencing laws, but the structure of our policy process and the way that we define crimes. Can you elaborate on the ways we can define crimes differently?
Yeah. There's this fascinating inverse correlation that I look at sometimes, and that is in Finland. They had crime rising in the 80s and the 90s the same way we did. And then at the same time, it went way down here. It went way down in Finland. But we did completely opposite things to address rising crime. We incarcerated far more people. In Finland, incarcerated far fewer people. And both apparently worked, which probably tells us that there's something else going on in both societies that's reducing crime. But part of what Finland did was that they criminalized fewer things. A lot of what they were seeing come into the criminal justice system was bar fights, closing time bar fights. And they just stopped having that be a crime. If you get in a fight, you get in a fight, go home, put a bandage on it. And they stopped criminalizing it. And that, it seemed to make things better. So we can redefine what is a crime. We need to be careful the way we do that so that we don't decay, the experience of being a citizen. The other thing too, in terms of defining crimes, is that narcotics is a field where we're already taking a hard look at should these be crimes, and should they be kind of the super crimes that we did with something like crack. The movement towards legalizing marijuana has really been a template. There was predictions in Colorado and other places where it was legalized, Massachusetts, that everything was going to go to hell. That the elementary school kids were going to be on the bus smoking weed, and it didn't happen. There are certainly changes, and one of the things that happened, and I thought this was pretty funny, was that the reports were that marijuana use in high school in Colorado went down after legalization, and part of it was, you don't want to do what your grandparents are doing. That's not very cool. But in terms of narcotics, this is hardly original to me, but the idea of mitigating harm is really important, and criminalization probably needs to be de-emphasized. There's other things too that are pretty archaic. Those of you that are 1Ls and are taking criminal law, you may have noticed when you get to murder that if I premeditate a murder, I'm going to prison for life. But if I intentionally kill somebody because they made me really mad and threw something at me and it's a manslaughter, then I'm looking at 15 years. That's pretty arbitrary, isn't it? I mean, the person who kills somebody because they're mad, that seems like a dangerous person to me. Now, certainly the premeditation is too, but the fact that we use states of mind that often are pretty hard to differentiate to create such huge disparities in crimes is also something that probably should be re-examined at some point. So I hope that answers the question.
Following off from that, do you feel that Oregon's decriminalization of drugs is a method that other states should follow?
Well, I think we're going to have to wait and see a little bit more. That there's international examples, places like Portugal, where they decriminalize drugs. One of the things about our country that I think people don't realize is that the demand for recreational narcotics is huge here. I mean, we spend more money on recreational drugs than we do on hamburgers, 10 times as much on recreational drugs as we do going to movies. We dwarf other nations in terms of our desire to take drugs. And there's social harms that go with it. there's no doubt about it. If your parents are using meth, it's not good for you if you're a kid. And there, so we have to be really attentive to the social costs of drug use and have a way to reduce drug use if we're going to move away from criminalization. But I'm really open to the idea that that can be a success, that these other ways of mitigating those harms of drug use and reducing drug use can be more successful than interdiction has been. Because frankly, interdiction hasn't worked very well. And part of it is because it's supply and demand. If you have constant demand for something, supply is always going to come meet it. We can reduce the supply for a while and price will go up, but then the iron rule of economics says that so long as the demand is there, the supply will show up. And that's exactly what we've seen in narcotics interdiction, is that we can have the biggest victory over a narcotic, but if the demand is there, the supply is going to follow. So
what steps can law students take today to help become better advocates themselves?
That's a really good question. And I've got a couple things. One is that it's good to find one issue. Instead of kind of being about, all y'all are bad or something, or the broad range, there's a lot to be said for focusing on one issue and boring down on it. And if you're going to be an advocate on something, it's really important that you get to know some of the people that are affected. There's nothing to compare to having a client in prison. And there's nothing to compare to talking to people who've been victimized by crime. That to be a good advocate, you need to be willing to engage personally with the harms that you're trying to correct. One thing too is that we live in an era right now where, partly because of social media, students can interact with anybody, basically. Find their Twitter feed, respond to what they're saying, if you agree with them or disagree with them. I always tell my students who are considering a job someplace, is there someone there that you want to be like in 30 years? At that firm, when you were a summer associate at that small firm, was there somebody who, you thought that I want to turn out like them? I want to have the kind of life and do the kind of work that they do. If so, go for it. You've got a path. You can get there. And I think with advocacy, that could be really important too. Find people who are really making a difference and follow them and study them, see what they do, how they communicate, how they express, and who they seek out as an audience. Interact with them directly, because we all get to do that. Frankly, that's how I started out. I reached out to the people I really admired in the field. I offered to co-author things with them, do research for them, and to write articles if they were doing a symposium. But I was also watching what they did and how it mattered. And so I think right now is a better time than ever to be a young advocate, because you have such direct access to the people who are making a difference.
In your opinion, does the privatization of prisons contribute to the overall lethargic pace of criminal justice reform? Alternatively, do you think that private prisons can be used as a tool for transforming the broken government-run prison system?
Yeah, there's a lot of discussion about private prisons, and certainly there's been some terrible private prisons and bad incentives. States where they sign a contract that they've got to keep a private prison full. Well, obviously that's troubling in the incentives that it creates. I think though that private prisons outside of when we look at immigration are a small percentage of prisons as a whole. And the people who really work on this, and I'm not one of them, tell me that as much as private prisons may be a problem in some places, almost everywhere the privatization of certain functions within a prison is a bigger problem. A phone company is going to provide phone services to a prison, and they're charging people $3 a minute when it costs them almost nothing to provide it. The medical services are provided. That, as outsourcing is everywhere, and it's been in prisons as well. And so while you can outsource the whole prison, that's relatively, it happens, but it's relatively rare. Outsourcing parts of it so that in a way that decays human dignity, that's much more common. Now, in terms of private prisons being an exemplar to a better way of doing things, I don't know. I mean, I haven't seen it. No one's come to me and said, hey, there's this great private prison, in Utah that is really doing some good things. And maybe that's true. Maybe I just don't know about it. But I would, if there's an exemplar of that, that would be important to know about.
Okay, so it looks like we have 7 minutes left. So I'll hand it back to you for some closing remarks.
Okay. These were great questions. I think one of the most important ones really was that question about how can I be a good advocate? What if I have something I deeply care about? And one thing you need to recognize is that if you're thinking that, you're already way ahead. I remember when I was a kid, my dad saying to me once, well, what you have to do is decide what you want and then go do it. And most people just don't do the first. And it's true. The problem in advocacy very often is that people don't get to that first step of finding something that they deeply care about and will have enough passion to carry them through the hard times. And so that's really important. And about those hard times, though, this is an important story to me. So when I was a prosecutor, I did a lot of crack cases. I mentioned that, and I believed in the sentencing guidelines. I thought that they would help remedy, among other things, racial disparities. That if everybody got the same sentence, then a Black person and a white person would get the same sentence, and it would help with that. But over time, my experience was otherwise in the court as a prosecutor. I just saw Black man after Black man being prosecuted. And there was a few federal defenders in Detroit who gave what we prosecutors disdainfully called the feudal speech. That I'd have a case where some 18-year-old would have 5 grams of crack and a gun under a couch cushion. And it was a mandatory 10-year sentence, 5 for the crack and 5 for the gun, stacked. And it was a pretty easy case to go to sentencing because, it was mandatory. The judge had to give the 10 years. So go to the sentencing, the judge would say, Mr. Osler, what do you want? And I'd say, Your Honor, it's a 10-year mandatory. We're not seeking anything more than that. And this is a first offense for an 18-year-old. 5 grams of crack is 5 sweet and low packets. And that kid would be in prison because there wasn't parole anymore until, for close to 10 years. But then they turn to the defense attorney and say, Mr. Densimo, one of the federal defenders was Andrew Densimo, what do you have to say? And he'd go on for 20 minutes. He talked about the effect of this on his community, that you could drive by that place where this guy was selling crack and there'd be someone else doing it now, that we weren't solving any problem, what it would probably do to this kid that we were locking up for 10 years. And then the judge would turn back to me and I'd say, Your Honor, it's 10 years. And off you go for 10 years. And that wore on me, we called it the feudal speech because there's nothing that was going to change because they made that speech. And I'm sure when they were making the speech, it seemed frustrating knowing that it didn't have any impact. But it made an impact on me. So when I started teaching, I started working on the crack powder disparity and took some cases pro bono, worked with the ACLU, and eventually took a case, and I lost a bunch of cases. I was like America's least successful appellate litigator. I lost in the first, the second, the third circuit. I lost in the 8th and 9th circuits on consecutive days. trying to argue that judges should be able to reject the 100-to-1 ratio categorically. But then I won in the Supreme Court. And it was the day after President Obama was inaugurated in 2009 that the opinion came out. And somebody called me, one of my buddies called me and told me about it. And then I got a call from one of the judges in Detroit, a man who recently died named Art Tarnow. And Judge Tarnow said, Osler, I saw that was your case. And I was like, yeah, it was. And he said, what happened to you? You were such a hard ass. And I said, well, and I kind of explained about the feudal speech and Densimo and everything. And Judge Tarnow said, did you ever tell Andrew Densimo that he changed your mind? And this is, 10 years later. And I hadn't, And so I called him up. But that's the thing, is that if you want to do advocacy, it's going to feel like you're giving feudal speeches sometimes, but you don't know who's listening. I don't know who's out there right now listening to me right now. But the fact is that you may be having a much bigger impact than you know. You may be changing things bigger than you imagine. That if you're right and you're passionate, that it's always worth making those feudal speeches. And that's part of that realm of advocacy as well. So I'll end with that.
Professor Osler, I cannot thank you enough for sharing your time in your article and all of your work with us. I cannot recommend enough to everyone to check out volume 54-2 of the New England Law Review with Professor Osler's piece and all the response pieces that he mentioned. So please check those out. And again, just thank you so much. We really appreciate it.
My pleasure. Thank you all.
Okay.